Let me start. Hello and welcome to this annual Eli Lauterpacht Lecture. I will first give the floor to Dr. Ivan Berkovich. Dr. Berkovich is a benefactor of the Faculty of Law and a friend of the Lauterpacht Center. His contribution enables us to offer this series of lecture in memory of Sir Eli. Dr. Berkovich, please.
Thank you, Professor Van Benesti. When the pandemic began in March, the decision was taken at the university to shift its lectures online. While we look forward to the time when we can all gather together in person again, the escape from our COVID-induced claustrophobia has allowed us to expand our reach around the world, and I'm thrilled to see so many audience members join us for this event. Today's lecture is one given annually to honor the memory of Sir Eli Lauterpacht, who founded the center. Eli's wide range of knowledge and experiences, together with his robust skills at argument and lapidary writing, ideally suited him to the role at Gray's Inn and before international tribunals as an outstanding lawyer. As a teacher, he was, in one word, excellent. He was a rigorous and exacting taskmaster, but we all tried to satisfy him because, as a consequence, we acquired the skill to reach his high standards. This instruction stood us in good stead as we pursued our own careers. But perhaps most of all, there was the inspirational and the philosophical Eli, calling out to the younger generation that despite everything going at the moment, they can make their dreams come true. For me, he achieved this venerated stature as a teacher by generating in us a faith, a belief in some kind of special energy that we possess, removing doubt and making us work as if it is impossible to fail. He saw us with the astonishing vision that had rendered him heroic as a mentor. To those who might not be intimately familiar with the Lauterpacht Center, let me say that it is a sanctuary encircled by gradation of intellectual and physical properties, where scholars speak with maximum clarity and resonance in a continuing dialogue on law in a noise-filled world. Here, an intergenerational mix of thinkers and practitioners are invited to engage in discussions that address the pressing legal issues in the world, ranging from climate change to immigration, to sex trafficking, etc. The case is made daily for the importance of international law and for the value of institutions from which we all have benefited. The stewards of the center, headed by Professor Eyal Ben-Benesti, have ensured that this intersection of contemplation and action, a noble bipartite objective, is carried out with the meliorism that fully represents the Lauterpacht legacy. And now, to our esteemed lecturer, Dr. Radhika Coomaraswamy. Dr. Coomaraswamy combines exceptional academic credentials with a passionate commitment as an international civil servant, advocating for the human rights of women and children in particular. She earned her BA at Yale and JD at Columbia and an LLM at Harvard. As a Sri Lankan academic, she has published widely on constitutional law and the status of women, among other subjects. She has served for a decade as UN Special Rapporteur on violence against women. Her courageous and groundbreaking performance has led one noted observer to comment, quote, "Some personalities working for the UN manage to raise the organization above itself through their indomitable courage and engagement. Ms. Radhika Coomaraswamy is such a person," end of quote. So I now call on Dr. Coomaraswamy to share with us her insights on women and children in the transformation of international law.
Thank you. Thank you very much. I want to thank Mr. Eyal Ben-Benis and the Lauterpacht Center, as well as Mr. Ivan Berkowitz, for inviting me to give this lecture here. I'm happy to honor the memory of Eli Lauterpacht, the person whose ideas, of course, filled our student days and all our work. And I want to dedicate my lecture to the Honorable Ruth Bader Ginsburg, who was my professor in law school and who taught me a great deal. Very few people take international law seriously. A system that is not pegged to a sanctions regime is sometimes denied the status of law. One patriarchal assumption is that if there is no punishment, there is no law, only policy or international relations. As Michel Foucault has outlined in his book, Discipline and punishment are at the core of the modern legal system. An analysis of developments with regard to women and children at the international level provide a different picture. They show another side to international law. The activism around these causes aim at international standards based on self-reporting and self-compliance. Sometimes observed in the breach, they still provide a framework for concerted international action. Their emergence has made a powerful contribution to how international law is perceived, and the debates around them have impacted the concepts and processes of international law. What I propose to do in this lecture is to look at important sources and concepts of international law and try and illustrate how issues relating to women and children have helped transform the way we reflect upon them, thereby changing the nature of international law. I will also quote from a book I am writing about the UN in the field to give a sense of what it means in practice. The 7 areas where the impact of developments in the field of women and children will be examined are firstly the concept of jus cogens as a peremptory customary norm of international law. Secondly, the process of multilateral lawmaking. Thirdly, in the concept of sovereignty, the concept of state responsibility. Then I will move on to the concept of human rights, the provisions of individual criminal responsibility, and then statelessness and the silences of international law. I will end with what I feel is the current position we are facing. Let me begin with jus cogens. The Paquet Habara case before the United States Supreme Court in the middle of the Spanish-American War is often cited as one of the cases that solidified custom as a source of international law in modern jurisprudence. Cuban fishing boats manned by innocent fishermen were seized by the United States and sold as a pride in the state of Florida. The court in its judgment goes on to describe the nature of customary international law and the fact that a seizure of fishing vessels during war violated such law. It also pointed out that the law is enforceable in the United States as customary international law, and that this is a part of domestic law, and its context can be proven in the courts of the United States. In this way, custom as a source of international law, even within domestic courts, came to play in many cases and in many jurisdictions. when a treaty was absent or unclear, customary international law gave it guidance. Since World War II, there has also been a great deal of discussion about jus cogens that many see as being part of customary international law, the apex of peremptory norms of the legal order. Jus cogens, that means compelling law in Latin, is an idea from Roman law that asserts that there are certain rules that cannot be derogated from. These are peremptory norms that are supposed to embody the fundamental values of the international community. Needless to say, there is a great deal of discussion and debate around these norms, their substance and their content. For human rights specialists and humanitarians, jus cogens is the soul of international law, and for the last few decades, they have set out to capture it. In some ways, aspects of jus cogens may be seen as an integral part of the doctrine of state responsibility, the rules that guide the twilight zone where non-state actors, national minorities, and aliens operate. As many have argued, there's a great deal of scholarly attention being paid these days to jus cogens, but there is very little case law and no directly relevant treaty law as to its content. However, for those interested in violations against women and children in times of war, the expansion of the doctrine to include serious breaches of international humanitarian law has been a cause célèbre. The discussion around this topic has become so intense that the International Law Commission included the topic jus cogens within its program of work in 2015 and appointed a special rapporteur. The rapporteur has filed 4 reports with detailed commentary that gives great clarity to the state of the discussion. The final contours of the doctrine of jus cogens are still in the process of being created. It's good to see that much of the activism of human rights groups has borne fruit, and the special rapporteur's draft on peremptory norms or jus cogens includes the major violations of international human rights law and international humanitarian law. The soul of international law is bending in the right direction. However, there are 3 glaring omissions: the prohibition against extrajudicial killings, the protection of children, and the prohibition against sex or gender discrimination. The list at the moment includes the prohibition of aggression, the prohibition of genocide, the prohibition of crimes against humanity, the basic rules of international humanitarian law, the prohibition of racial discrimination and apartheid, the prohibition of slavery, the prohibition of torture, and the right to self-determination. There's a great deal of debate as to why international drafters, like the International Law Commission, refuse to include, for example, the prohibition of sex discrimination. Women lawyers have argued that every international forum has passed resolutions on women's rights and sex discrimination, perhaps more than any other topic. They point out that if race discrimination is mentioned, so should sex discrimination. On the other hand, conservative international lawyers point out that state practice with regard to sex discrimination is not keeping up with the norms, and that misogyny is not universally condemned. And yet, universal compliance and expert opinion cannot be an absolute requirement when Alan Dershowitz, a leading law professor at Harvard University, has justified the use of torture. The prohibition on race discrimination, as the last few months have clearly shown us, is also usually observed in the breach. If both these provisions are jus cogens, then prohibition on sex discrimination cannot be objected to on the ground of the need for full compliance. We must accept that many of these issues that we take for granted with regard to sex discrimination and violence against women are still disputed. Let us take the questions of female circumcision or female genital mutilation. For writers like Alice Walker, it is torture. And even if there was no separate category in jus cogens for sex discrimination, it would fall under the torture category. For others, like the Minister of Women's Affairs I met in Sierra Leone in the early 2000s, it was part of a graduation ceremony for young girls who complete training on what it takes to be a wife and a mother. After a young girl menstruates, she is taken with the other girls to a special hut or dwelling place, where they're trained and taught on how to be a good wife and mother. When they finish this month of fellowship, they're then subject to female genital mutilation. Circumcised women then become part of a countrywide secret sorority. Many of them become the custodians of this ritual for future generations. These are the kind of practices that commentators point to show that the prohibition against sex discrimination is not used in concordance. These realities in one part of the world cannot stop norms from emerging in other parts of the world or at the global forum. Regardless of those realities and a genuine attempt to understand them, an enumerated list of use cogents without sex discrimination is just not acceptable in the top half of the 21st century, given all the international, regional, and national initiatives, including those against female genital mutilation. The initial crusaders against female genital mutilation, the early mobilization was by Nawaz al-Saadawi and Azm al-Jarir, medical doctors from the global south who devoted their lives to fighting this practice. It is their guidance, coming from the areas affected, that should give direction to the writers of these provisions. We may have a conversation about how we prohibit this practice, the ways and means while respecting cultural values, but the general prohibition must stand. It must be part of use cogents. The special rapporteur on use cogents keeps pointing out that his list under use cogent is non-exhaustive, that it is flexible and subject to change, and even develops the concept of a regional use cogents. In such a situation where the law is dynamic and in the making, the prohibition of all aspects of sex discrimination as part of use cogents must hopefully evolve and become part of the foundation of international law. The protection advocacy must also be done for the protection of children. Now I want to say something about multilateral lawmaking. Another source of international law besides custom is, of course, the treaty. When I went to law school, this meant an analysis of primarily bilateral treaties following the directions of the Vienna Conventions and analyzing how states accept, modify, or terminate such agreements. Since then, the major source of treaties making, as Jose Alvarez points out, is now increasingly the grand multilateral conventions adopted by the General Assembly of the United Nations. The first such convention after World War II was the Convention on the Prevention and Punishment of the Crime of Genocide. It defines genocide, places obligations on states, and requires that all disputes between states be referred to the International Court of Justice. The convention aimed at universality and was humanitarian in substance. Over 150 countries have ratified the convention. The multilateral conventions passed by the General Assembly have a certain pattern. An idea or issue originates in academia, civil society, and among policymakers, and enlists a large number of proponents. A group of states are called upon to sponsor the idea and bring it into the international community, either through world conferences or the various commissions and committees set up by the United Nations. After the idea enters the organs of the United Nations, there's a consultation, and usually a study is commissioned. Once the study is submitted, the UN organ that is responsible for directing the idea takes control of the process, and the drafts are similarly submitted, usually to a committee of the whole, and negotiations begin. In the case of CEDAW, or the Women's Convention, the Commission on the Status of Women took 7 years. The convention is then adopted by consensus. The Women's Convention and the Children's Convention added certain distinct elements to this style of treaty making. Firstly, they were very inclusive and were embarked upon only after world conferences and extensive consultations with both state and civil society. It was not the case of drafts and discussion only among diplomats and their legal advisors, as was the case with earlier conventions. A global movement on women's rights and children's rights worked for and created public opinion for the enactment of the conventions. This became a model for many other treaties. The multilateral convention has become the rallying call for social movements and to transforming society and respect human beings. The climate change movement now does the same for the environment. Conventions are recently more than diplomacy and the art of the possible. Like the Women's Convention and the Child Convention, they try not only to be universal, but also transformative. For example, let us take Article 5 of CEDAW, the Women's Convention. State parties shall take all appropriate measures, A, to modify the social and cultural patterns of conduct of men and women, with a view to achieving the elimination of prejudices and customary and all other practices which are based on the idea of the inferiority or the superiority of either of the sexes, or on stereotyped roles for men and women. If I may repeat, they say to modify the social and cultural patterns of conduct. The idea of international law that is transformative, that establishes norms with the expectation that not only nation states, but that individuals will fall in line and actually affect the bodies of their citizens, truly originates with the Women's Convention. Changing the behavior of whole populations is a formidable goal, keeping the pathway for change always open. In addition, the optional protocol to the Women's Convention allows women who have exhausted domestic resources to bring their case before the CEDAW committee. Countries that have signed the protocol are bound by the decision of the committee. Individual vindication is an added benefit of the CEDAW system. The first case in 1978 involved Mauritian female spouses married to foreign men, suddenly finding their family life limited and disrupted when their foreign husbands were subject to capricious decision-making with regard to the grant of immigration visas. Male Mauritius spouses had no such problems. This spousal discrimination led the committee to hold that Mauritius had violated its obligations under CEDAW. In addition to being transformative, CEDAW is expert-based and not diplomat-led. CEDAW, like the International Covenant on Civil and Political Rights and the International Covenant on Economic and Social Rights, sets up a committee of experts to monitor the reports of countries filed every 4 years. This, along with the shadow reports filed by civil society, allows an occasion where a country is questioned quite extensively on its performance and conclusions, and recommendations are written accordingly. These recommendations can be used to mobilize action and opinion back in the home country. Trial by technical and expert committees is the preferred option of human rights treaties. Is this process successful? We have never really tried to answer that question. Professor David Kennedy has forever warned us that technocrats are taking over human rights. The processes in place do support his analysis, but is it necessarily a negative thing? Do we need to bring morality and politics back into human rights, the Women's Convention and the Child Convention? We must await more comprehensive and diverse assessments about the style of international monitoring and decision-making before we come to any conclusions. Since CEDAW, there have been many multilateral conventions with a similar transformative calling. Climate change is the phenomenon of our current era. It has all the inclusiveness and dynamism of the Women and Children's Convention. These multilateral processes are world events, and though their final product is often not satisfactory, they are occasions where the world comes together for dialogue, discussions, and decision-making. They are the only means through which issues of global interest can be addressed while respecting diversity of opinion. Increasingly, such processes are sniped at and devalued and made fun of in a world where contempt has overtaken reason. Nevertheless, their importance for a world evolving toward an era where human dignity is respected is undeniable, and one can only hope that they will be able to move forward again. Let me now say a few words about the concept of sovereignty in women and children. As our traditional teachers have taught us, The nation state is the founding block of the international system. The concept that cloaks its autonomy and uniqueness is the concept of sovereignty. While internally democratic sovereignty has meant the people and a system of government, at the international level, it has always represented a cloak, a protection, and space for decisional mobility. As commentators have said, sovereignty means that a government possesses full control of affairs within a territory or geographical area. Sovereignty may be seen as a rational organization of the world order, but in some countries it is imbued with mystery and danger, a site for expectation as well as darkness. The concept of sovereignty is recognized as emanating from the Treaty of Westphalia that was signed in 1648 after a 30-year religious war. It is estimated that 8 million people were killed during this long and cruel war. The end of any war with so much pain and suffering always sees a quantum leap in the growth of international norms and standards. The Treaty of Westphalia in 1648 called for the non-interference in the affairs of other states, while World War II would give birth to the concept of human rights. Sovereignty is not absolute, and much of modern debate remains about its contours. Under traditional international law, the doctrine of state responsibility limited the power of the sovereign in the international sphere. Historically, it was used in the case of free aliens and diplomats. However, it has become a more flexible and dynamic concept, preventing sovereign overreach. After 45 years of deliberation, the International Law Commission completed its draft articles on state responsibility, which were accepted by the United Nations General Assembly in 2001. M was 38 years old and lived in the area around Taba, Rwanda. During the genocide, she, a Tutsi, saw her neighbor's house being burnt with the neighbors inside. Her family fled for their lives. Like many Tutsis, they rushed towards state sanctuary, the compound of the mayor of Taba. Instead, the mayor ordered that all Tutsi males be killed. The family ran from the compound and huddled in a house. The Hutu Interahamwe followed them and killed all the men and boys. They took them to a large pit full of bodies. The women were then asked to bury them. They took M's baby son and threw him also into the pit. The older son was only partially wounded. He was also thrown in. He screamed for his mother. M and all the other women were forced to bury fathers and sons. Some were alive. Their pleas constantly played in her ears. M went limp and fainted. She and other women were then taken away and repeatedly raped and gang raped. She did not know how many times, and she did not care. General Romeo Antonius Dallaire was the head of UN peacekeeping operations Rwanda in 1993 and 1994, the year of the genocide. He pleaded with Kofi Annan, who was then Assistant Secretary General of Peacekeeping, to give him the approval to intervene, to collect weapons, and to help prevent the genocide. Annan, after consulting President Clinton, who had become cautious after recent failures of peacekeeping in Somalia, did not give the approval. Dallaire was helpless. Up to 1 million people have said to have died. When he returned to Canada, Dallaire had an extreme case of post-traumatic stress disorder. After he recovered, he became a crusader for the international community to have a better process to deal with genocide and crimes against humanity. The Canadian government sponsored an international commission on intervention in state sovereignty. The report of the commission was widely circulated, and Kofi Annan, recovered from the Rwandan failure, became one of its proponents. Framing the international response in the context of state responsibility for serious breaches, Annan put forward the responsibility to protect doctrine with regard to 4 areas only: genocide, war crimes, ethnic cleansing, and crimes against humanity. doctrine had three pillars. The first, that every state has a duty to protect its own citizens. The second pillar was that if a state begins to fail to protect all or some of its civilians, the international community had a collective duty to work with the state to prevent serious breaches. If the serious breaches persist, look like they will become a threat to international peace and security, then Chapter 7 of the Security Council process comes into play with the veto structure in place. Bilateral interventions for the supposed protection of civilians have taken place over the years. Tanzania went into Uganda to get rid of Idi Amin, Vietnam into Cambodia to get rid of Pol Pot, India into Bangladesh, and more recently, the protection of civilian doctrine was also invoked for the invasion of Iraq. Bilateral interventions, by their very nature, may be an excuse for aggression. For that reason, the doctrine of the responsibility to protect was initially welcomed as setting up a multilateral, as opposed to a bilateral process of cooperation for the protection of civilians. Precisely because of the Iraq connection and the UN's foray into Libya, responsibility to protect that was initially welcomed by heads of state in their outcome document in 2005 became a very controversial doctrine, especially in academia. Those incidents points to the doctrine could be manifestly misused, though the veto structure may both prevent action when necessary and curtail over-enthusiastic member states. And yet the story of M must make us realize that there are times when the responsibility to protect is an important concept. Drawn out of the doctrine of state responsibility, it is not a legal doctrine, but a political commitment to action. Even if the use of force is discarded due to its perceived dangers, the first two pillars of the responsibility to protect, that of the state taking responsibility for atrocities in its territory, and the heightened diplomacy by the international community, remain very important. The Secretary General of the United Nations now has an advisor on the responsibility to protect. One of the main caveats to come out of the discussions on the responsibility to protect has been to ensure that the world is on alert with regard to mass violations. Throughout the world, early warning systems are being set up to monitor serious breaches. The main indicators being looked at with regard to the protection of civilians are indicators related to women and children. The number and nature of violence against women, crimes against children, child soldiers, these are the first signs that the social fabric is being torn apart. The Security Council has three thematic areas where it is actively engaged: children and armed conflict, women, peace and security, and sexual violence and the protection of civilians. In these areas, there is a detailed consideration of these themes, and in the case of children and armed conflict, a particular working group that monitors country situations. Both the children and armed conflict mandate and the sexual violence mandate involve naming and shaming, and the listing of parties that have committed grave violations. When I arrived in the Central African Republic, I was told that Commandant L, who was listed in our annexes to the Security Council report for having recruited child soldiers, wanted to see me. I was warned that he lived 2 hours into the harsh jungle and in the midst of conflict with Chadian soldiers. We got into two vehicles, one full of support staff and one with security detail, and headed off to meet the elusive commandant. He had given us a location of a broken down church inside the tropical jungle. The security detail was not at all happy about this excursion, though OCHA and UNICEF felt it was an important engagement. As we drove further into the jungle, we could see the usual devastation of war: broken walls, burnt buildings, and ghost towns clustered in every corner. They were all around us. There is nothing more eerie than lush vegetation and burnt buildings embedded in each other. Dried up wells, lonely goats and dogs braying in the silence, I felt a deep sadness. We drove for 2 hours in this landscape till we reached the church. It was broken down and completely deserted. We sat down on the broken benches for seemed like some time. Then suddenly there was a commotion. 2 girls wielding AK-47s came running into the church. They took one of the benches and put it under the trees. Then they made us move and took the benches we were sitting on and put them in front of the other bench in the blazing sunlight. And they motioned for us to sit there. We waited for a while, and just when I thought I was going to die of sunstroke, a colorful parade emerged. 2 aging motorcycles led the way, and then came this man on an animal that half resembled a donkey and half resembled a horse. He saluted me and sat down on the bench under the tree and then said, "What is this about the Security Council?" So I described the Security Council process and the naming and shaming of parties in lists to recruit child soldiers. Then a slightly quivering voice, while looking at his AK-47, I told him politely that he was on the list and in the future could be subject to sanctions. He went ballistic. "Don't they have better things to do?" he shouted. He then gave me his own history of the United Nations that he called the League of Nations. It was a history I had never heard before, but the central theme was that he somehow personally suffered. I was so surprised that he cared at all, that he wanted to get off the list. I was surprised that he did not tell me to go to hell. At this point, he jumped up and dragged some of the child soldiers, both male and female, by the ear, and brought them to me and said, "Is this who you want? Okay, take them. They think I'm their father. See if they're happy with you." At this time, the horse or donkey that had brought them and the commander broke free, and everyone, including my security detail, went running after it, leaving me to ponder what to do. Meanwhile, Commandant L was becoming restless as he was hearing gunshots. My UNICEF colleagues, as reassuring as they usually are, said, "You have delivered the message. We will take it from here." Commandant L went on to release about 600 soldiers to UNICEF programs. Releasing children associated with armed groups was the cause célèbre of the upturn of the century. Thousands of child soldiers were used by armed groups. Sexual violence against women and girls was the other issue that was receiving international condemnation. Any developments in these areas would immediately trigger international protection mandates. The protection framework that comes out of international humanitarian law, that is distinct to patriarchal protection that discriminates against women, comes from the experiences of women and children during war. What happens to women and children then is an indicator of a system racing towards serious violations. And during the war, their experiences becomes a major ground for accountability both of state and non-state actors. They make the drive to make international law more responsive through the doctrine of state responsibility, responsibility to protect, and the discussions and jurisprudence comes from groups concerned with the protection of women and children. Academia in much of the global south is for the most part against these emerging protection doctrines of international law. Fearing that this will be a cat's paw for imperialism, they sometimes join their governments in resisting many of these developments. I have both a humanitarian and an academic background. Protection is a noble aspiration, but all such efforts must be open to the critique of political realism that will help us understand how these ideals are being used and manipulated in practice. One has witnessed the misuse of international law and its protection doctrines. Nobody is naive in believing that state humanism, is not backed by material self-interest. And yet universal condemnation and united action in international humanitarian law is absolutely necessary, as I found in my work in the field. And a rules-based system, despite its abuses, is far more protective of the global south than a system that is raising its head today of self-interest with impunity. I want to now do a little discussion of human rights and women and children as it relates to the doctrine of human rights. After 30 years of brutal war in 1648, the concept of sovereignty was born to keep less powerful states safe. After World War II, the doctrine of international human rights emerged and would find a permanent home in the United Nations. Holocaust-driven and overwhelmed by horror, scholars and policymakers agreed to give it centrality. American law professors like Samuel Moyn have displayed a measure of arrogance in hijacking human rights as an American tradition, while much of the initial life of human rights was spent accusing the US as being complicit in global human rights violations. This rewriting of human rights history, locating human rights as a copyright of US human rights groups and not as global collective action, has seriously compromised our understanding. The history of human rights within the UN system has 4 phases. The first phase, led by Eleanor Roosevelt, was the standard-setting phase. The Commission initially drafted the Universal Declaration of Human Rights. For the next 20 years, the UN would play this role of researching and codifying international human rights law, producing 2 covenants and the Convention on Genocide and Torture. The second phase of human rights developments within the United Nations, when the UN moved beyond setting international standards to commenting on what is actually taking place within countries, that is piercing the veil of sovereignty. The first such action was to set up an ad hoc working group of experts on Southern Africa in 1967 to look into the problem of apartheid. Apartheid agitation convinced countries that we had to go beyond paper and that naming and shaming must also take place. This was followed in the 70s and 80s with the setting up of the Working Group on Disappearances and a special rapporteur on torture. These were driven by the developments in Latin America, where military juntas ruthlessly repressed their populations. Contrary to some of the assertions of Professor Samuel Moyn, the first cases of human rights, those that defined human rights for half a century, had their origins in social solidarity with progressive movements of the Global South. In recasting human rights history as having its origins with Human Rights Watch and the Helsinki Accords, Moyn erases these struggles of the Global South by enforcing an authoritative American voice. The third phase of human rights took place in the 1990s after developments in Eastern Europe and the wars in Bosnia and Rwanda. It may be called the golden age of human rights, plethora of resolutions, mechanisms, and the creation of the International Criminal Court. And the fourth phase of human rights began after September 11th. There was a complete rollback of political and civil rights in the name of counterterrorism and the instrumental use of human rights as a justification for bilateral military action. Michel Foucault writes about the security practices and technologies that nation states apply to control large populations. With regard to the political sphere, that control is now near universal. Surveillance technology, satellite technology, social media technology, along with government practices in the name of counterterrorism as heightened security practices and greatly reduce the space for human rights. It is well recognized now that women and children are a specialized area within human rights. Though the distinction between women and children must be kept in mind, with regard to the process, the international system created a connection between them, especially during times of war. I'm going to skip. I have a section on women combatants, but do I have time? How much time do I have? Iman?
I'm not coordinating this, but if it allows us to get more insight into what you're proposing, I would suggest that we continue.
Okay, thank you.
Let's say, if I can intervene, there are a couple of questions from the audience, so maybe another 5 minutes or so.
No, I will take another 15 minutes I need.
Oh, okay.
Is that all right?
And then we'll take the questions later. Okay, thank you.
All right. The framework that puts women and children together is the framework of protection from international humanitarian law. Protection in that context signifies a certain vulnerability to violence exploitation, and abuse. The United Nations, in its humanitarian work, still continues to deal with them in that manner. The emergence of women and child combatants has made many people question our assumptions of protection as the proper framework, especially with regard to women combatants. Women have resisted the coupling of women and children, fearing they will be infantilized. Their fear has some resonance when we deal with women combatants. What is protection? What is rights? International law and UN mechanisms generally ignore this reality of women combatants. Security Council Resolution 1325 on women, peace, and security does not even mention them. It is assumed that they are victims who have been brutalized, tortured, and exploited. Saving or rescuing them is often the frame of reference. I do not want to go home, she spat out. I want to stay here and join the army like the boy soldiers. We explained to her that the Nepalese army was not accepting female cadres. She did not believe us. In her eyes, we were demons, and her whole demeanor showed us contempt. All those special courses on computing that the UNDP had spent devising were of no avail. I felt sad that she was being taken home against her will. Girl children in Nepal were often treated very badly and abused. She would probably run away again, this time not to join the Maoists, but perhaps to be trafficked to India for prostitution or for cheap labor. The story of female combatants is a complicated one. Some paint them as victims of abduction and brutality. In other narratives, such as female Kurdish fighters, they are portrayed as heroines taking women's freedom to its limits. As Dharani Rajasingh has written in a series of articles, in most cases, they really enjoy an ambivalent agency. Rarely are they decision makers or power breakers, but they learn skills, attitudes, and self-confidence that make them enjoy a relative amount of agency. To protect that agency while preparing for peacetime is perhaps one of the biggest challenges for peacebuilding. This whole area of women combatants needs fresh thinking precisely because we allow them greater agency. For example, with regard to international law, there may have to be a whole new approach to the issue of prisoners of war and how women POWs' rights and dignity can be protected. In doing so, perhaps we can better explore the tension between protection and human rights. If we return to the mainstream issues of human rights, the tradition developed by those involved in the furthering of the rights of women and children have contributed to the introduction of certain concepts into international law. For example, Article 1 of the Women's Convention states, "The discrimination against women shall mean any distinction, exclusion, or restriction made on the basis of sex, which has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise by women, irrespective of their marital status, on a basis of equality of men and women, of human rights and fundamental freedoms." At the time the convention was written, and even today, in many parts of the world, the words "the effect or purpose" are a radical construction of equality. It moves us away from Aristotle's more formal sameness doctrine into looking at the actual effects with regard to discrimination against women. The ICCPR, for example, only talks about equal rights. With regard to the Children's Convention, instead of father or mother or parental preference, the term best interest of the child became the international standard. The principle calls for the case-by-case treatment of children, focusing on their views and aspirations, their care and protection, and as well as their well-being. Perhaps the most innovative part of the women's human rights movement at the international level was the struggle to bring international recognition of the question of violence against a woman. Today, every donor and every women's group foregrounds violence against women, so much so that questions of women's labor and social and economic rights, which first concern women, are rarely dealt with. I would go on to say, and I hope I will publish this somewhere, but just to say that the whole violence against women movement was from all parts of the world, trafficking in Southeast Asia, domestic violence, and honor killings in Latin America. And it was a global movement that came together in the 1990s and became part of international law, which at that moment was not looking at domestic violence or violence against women in any form, through CEDAW and through the CEDAW committee, it is now a part of international law. And the doctrine of due diligence is used with regard to violence against women also to ensure that those who commit violence against women are prosecuted, and there is no impunity for private individuals who attack women and children. I have a section on state responsibility, including something on my presence in the International Criminal Court, where I gave evidence in the case of Thomas Lubanga, which I can read later if you wish. But maybe what I will, and I talk also about sexual penetration. I don't know how I managed to misjudge the time so much, but I want to just end with where we're going. I do have a section on statelessness as well, but that also, I suppose. Now I would like to focus on the backlash and some of the challenges that we face today as we try to make the case for international action on women and children. The extraordinary developments where international law and action have been the standard bearers for both the women's and children's movement are now moving at a much slower pace. In the area of sexual violence and armed conflict, international norms and actions are developing quite strongly. But in other areas, such as women's sexual and reproductive rights and women's economic and social and cultural rights, we are poised to move backwards. No one dares call for a world conference or a reckoning of the rights we have today for fearing the loss of hard-earned gains. Since the 1990s, with regard to women's rights, there are also challenges from within. There's a question of who is a woman that's determined by the Women's Convention. The heated discussion about transgender rights and the refusal of leading celebrities to let go of the biological formulation of women as sex, not gender, has caused a great deal of controversy. Arguing that many of the rights fought for and won at the international were for women, the biological sex, they resist the attempt to conceptualize women's sex and gender differently. Trans activists and LGBTQ activists insist that women must be seen as an inclusive concept, embracing the issues and grievances of their community within the fold. As civil society is broken across the board, momentum is now harder to find. Nation states as a whole will not have...
We can hear you.
Oh, sorry, okay. Nation states as a whole will not really venture into this field. When the Rome Statute was being drafted, there were attempts to have a more complex understanding of gender identity. The comeback of nation states, led by the Vatican, was contained in the provision, Article 7.3 of the Rome Statute. For the purpose of this statute, it is understood that the term gender refers to the two sexes, male and female, within the context of society. The term gender does not indicate any meaning different from the above. Today, there is also advocacy to recognize the vulnerability of men and boys, especially in the area of sexual violence. All these developments are healthy and meaningful, but complicate the binary that made earlier universal mobilization for change effective. There is the need for imaginative conceptual thinking to bring together all these diverse strands. Another challenge from within has been the challenge of diversity and intersectionality. Kimberly Crenshaw described the fact that women's lives are at the intersection of race, ethnicity, class, and caste. For a full understanding, any analysis must begin at the intersection. In this way, diversity was brought into the discussion of women's rights. Southern feminists also began to be critical of what one may call the arrogant gaze directed at their social and cultural practices. A more nuanced understanding of difference and what it means to be different is considered to be extremely important. The major challenges are not only from within, but through the growth of extremely conservative right-wing movements that challenge the very basis of international law and believe that a woman's position should be according to her faith. Woman as only wife and mother and complete parental control of children are norms that have made a comeback, and regressive standards seem to be seeping in. But the future is not completely bleak. While there are strident calls to limit sexual identity, sexual and reproductive rights, and assign women conservative places in society, women, and especially young girls, are bounding out of the limits placed on them, entering every field of occupation, reaching new heights, and beginning to fill government and boardrooms, though there is some distance to go. The next disconnect between the ideologies that fill mass media and the actual lives of young women is something worth watching. One of the Millennial Development Goals that has been reached easily is girls' education. I have never seen anything like a girl's demand for education. Whether it was Aisha in Afghanistan, whose house and school were bombed, or a young, desperate girl demanding secondary education in Dadaab, a Somalian refugee camp, or Malala herself, now an Oxford graduate, their thirst for education was overwhelming. As our generation remains paralyzed by its inherent contradictions, it is these young women from the global south, along with their northern partners, who will probably revive international law and international action in the years to come. Finally, there are two possible endings for a lecture of this kind. The first, that we may call the Mongol invasions and the destruction of civilization, would predict the demise of the rules-based order and international system that we have come to take for granted. The international rights of women and children can only survive within a rule-based system. Without rules, there is no protection or rights. Commentators argue that a rules-based system will be replaced by an era of deal-making and handshaking, guided by Machiavellian Kautilya rather than positivists and natural lawyers. The Enlightenment project will be overthrown by populist nationalism, suspicion of science, and the nation-state refusing to bow down to an international regime. In this scenario, all that I have spoken about will come to an end or will occasionally reduced at the international level. The second ending that I prefer will be more reminiscent of what I would like to call dialectics. The extreme forces that are in existence today will interact with rules-based system, forcing a reckoning, and a new and more enriched rules-based order will emerge. As we watch young people like Greta Thunberg and so many others who are mobilized around climate change, we know that social movements fighting for a more comprehensive and equitable rules-based system have not died. They have reemerged in different guises, and they highlight the need to see ourselves holistically and act together as a global community. In that resurrection, one can only hope that developments with regard to women and children will continue their march forward in a richer and more diverse way. I'm sorry I mismanaged my time.
Thank you. Thank you very much for this insightful and inspirational lecture, sharing with us your diverse experiences. It's really a good start for the year, especially this day and age. There are a couple of questions for you, if you care to. We have a couple of minutes to.
Can you read them to me, because something has happened to my screen. I don't. I have only the picture of me. I don't know what has happened.
Yeah. So the first question is from Professor Ruth Halperin Kadari, from the former vice chair of CEDAW, and she says, she writes, "Thank you very much for this important and comprehensive presentation. Am I correct to understand that, in your opinion, prohibition on sex, gender discrimination should also be regarded as jus cogens? If so, what would be the substantive content? Would you suggest that CEDAW's jurisprudence would fill this role?"
Yes, I feel that it is very important that CEDAW take part in these discussions on jus cogens that are taking place at the International Law Commission, because the Special Rapporteur has left out sex discrimination as jus cogens. And I think it is very important. There are humanitarian groups that are pushing for it, but I think if CEDAW can be active and maybe write a memo or in some ways intervene with Special Rapporteur and the International Law Commission, making a case as to why discrimination against sex discrimination should also be a prohibition under jus cogens, I think it would be very useful.
Thank you. The second question comes from Ross, a student at Cambridge. Dr. Coomaraswamy, thank you so much for this insightful lecture. You have mentioned about the importance of the use cogents and limitations to sovereignty. May I ask, given your experience as a diplomat and academic, to what extent can we say that international law is still based on the doctrine of consent against natural law?
I think it is still, for the most part, based on a doctrine of consent. Except, and that's what I wanted to, I had a section on individual criminal responsibility, where the nation state consents, but the individual, of course, is tried under the Geneva Conventions, or if they have consented under there's consent-based jurisdiction for the nation state, but there's also criminal process that takes place with regard to individuals. And I just wanted to highlight, which I do in the document, which hopefully I'll one day be able to, how, for example, sexual violence is now being defined internationally because of the international cases. So there sexual violence in wartime, and how it begins with Akayesu case, where they define it as an physical invasion in a coercive atmosphere. That's how they define it in Rwanda. And if you look at Rwanda, there's no other way to define it. To talk about consent would be a real disaster. I mean, it wouldn't make any sense. But in the former Yugoslavia cases, they talked about consent and women's autonomy. And now back in the ICC, there's this pull between those who want to talk about coercive atmosphere and we don't want to look at consent, and those who are saying, how can you have rape without looking at consent? All these discussions still going on. The law hasn't been finalized. And it's also a pull between seeing in a situation of war, how much is it a consent between individuals and how much is it patriarchy and power and things like that. And that's a very vital conversation that's going on now on sexual violence. So then, will nation states adopt international definitions of rape that come out of the court processes of international courts? Also, child soldiers, will they define how? That's also, this was what I was going to describe, my testimony before the International Criminal Court in that first case, Kibaga case, where on enlisting, conscripting of children. And again, the court had a very broad description of children because the humanitarians pushed for that. I did that in that amicus curiae, so that you would give the broadest protection to children and they could be demobilized in humanitarian programs, and that participating actively in conflict was seen as broadly. So there is now a development through the courts, not only the black letter law, but developing through international courts, new definitions of important areas. How much will that impact on local countries? So I moved away from the answer on consent, but just to say that nation-state consent is now much more the way the world functions, international law functions, especially on issues of women and children. It's a much more complicated than just nationwide consent. I mean, you consent in Article 5 of CEDAW to modify, based on international standards, to modify the behavior of your population, which of course you still consent, but it's a much more intrusive international norm. So I just want to say that women and children, it appears that the world is ready to accept intrusive norms, which it won't accept in any other area. Hello?
Hi,
Hello?
Radhika. Oh.
Have we lost you? Have you lost me?
He's back. I think Ail dropped out for a minute, but he's back now.
Okay.
I think he'll be able to read the next question.
Sorry.
I have lost the video. I don't know what has happened. I only see myself in a little corner. I've lost the Zoom, but anyway, that's all right.
So the last question that I'll read to you, the third question in the row. Sorry for being disconnected. Dr. Coomaraswamy, thank you for such an inspiration. Judge Viramantri wrote, and I quote, "The legal profession, more than any other body in society, has a responsibility to promote an awareness of the law." Do you agree? And then how can we explain to the importance of international law to school children and their rights when, for example, the UK government not only proposes to breach international law, but is enshrining such breaches in an act of parliament? This is a question from Professor Marcus Gehring from the Lauterpacht Center and Cambridge University.
Yes, well, I think it's the legal profession has an ethical duty to take as international law, and especially those aspects of international law that, as we say, the whole idea of jus cogens is the idea of what is the essence, so universal and so fundamental to human beings that it cannot be derogated from. And so to take that idea, and I think it's very important that lawyers accept that and teach that and promote that and raise awareness about that. Legal profession, increasingly, even in my society, has played a positive role. That we are having some issues here. The Bar Association and others, they are getting together and playing a constructive role. So I think it is happening in different parts of the world where lawyers, especially in the global south, I find India, Kenya, and other places, where lawyers are getting together and leading the way in a lot of the struggles on human rights, on those aspects of law. But I think it's crucial that lawyers part. Human rights is, even if you don't want to impart all those human rights because there's social, economic, at least the jus cogens norms. I think it's absolutely crucial.
Dr. Coomaraswamy, I want to thank you again for sharing your wisdom with us. It was an inspirational talk, and I think maybe the most important thing for us as international lawyers was your the insight that international law should not be taken as a given. It's something that we take part in its evolution. So each and every one of us has an important role to play, and you are certainly a role model for us. And so we wish you all the best in continuing your efforts and for sharing your experience with us today. Thank you very much.
Thank you. Thank you.
So, and I want to invite all the viewers to our next session, next Friday, part of the ongoing series of lectures every Friday afternoon, 1 p.m. UK time. Thank you very much.